The Supreme Court passes a split verdict on a batch of appeals challenging restriction on Muslim girl students wearing hijab in educational institutions in Karnataka. Justice Hemant Gupta dismissed the 26 appeals filed against the judgment of the Karnataka High Court, which held that hijab was not an essential practice of Islam and allowed the ban on wearing headscarf in educational institutions in the state. Expressing divergence in his opinion, Justice Sudhanshu Dhulia set aside the Karnataka High Court judgment and held that the entire concept of essential religious practice was not essential to the dispute. Justice Dhulia said that the Karnataka High Court took the wrong path and hijab was a matter of choice, nothing more and nothing less. Dhulia claimed that the foremost question on his mind was the education of the girl child. Meanwhile, the Basavaraj Bommai government claims they will continue to enforce the hijab ban in the state.
At the moment, there is no stay on the Karnataka High Court verdict. There has never been a stay on the Karnataka High Court verdict from the Supreme Court. So does that mean that the status quo and the operation of the Karnataka High Court verdict will continue?
See, it requires at least two judges to stay the judgment, and because now the matter, there's been a disagreement and the matter is still pending in the court, so the question of what happens next is still at large. So either the Honorable Chief Justice will constitute a bench, which will then decide at least on the interim what will happen. But until then, status quo is likely to continue because in that sense there is no change insofar as the ground position is concerned.
And this bench has not made any observations, at least in open court, with regard to the High Court operation of the High Court verdict.
So the order that they passed at the end, a conjoint order, was that the file be placed before the Honorable Chief Justice for constitution of an appropriate bench. That's the only order that was passed.
Are we likely now to see you or any of the other petitioners going to the Chief Justice and asking for an urgent resolution to this?
That is, see, we do wish for an urgent resolution of the dispute, but at what stage, mentioning, etc., all these things are matters of strategy that all the parties will collectively have to decide as to when, we have to move an application, appropriate application, how long that will take is not something that I can immediately comment on. That's something that all the parties and all the council together will take a decision.
Justice Dhulia has differed with his view, and he has expressed that he has a differing view because a girl child faces a lot of problems while they are being sent to the schools and colleges, and their right to education is more important than wearing or not wearing a hijab.
Well, I think it's a far-reaching decision. Nothing comes, in a sense, effectively from this decision because it's a split decision between two honorable judges, and therefore the matter has been placed before the Chief Justice to take the matter forward, which would either be referring it to a constitutional bench because that was a point that was involved, or it will just go to a larger bench of three judges that will resolve the conflict. So we have to wait as to what happens.
We have a student called Noor Fatima. Thank you for speaking to us. आप इस सुप्रीम कोर्ट वर्डिक्ट के बारे में आपका क्या इरादा है?
हिजाब हमारे लिए इम्पोर्टेंट है. ये हमारे रीजनल पहले से चले आया है, लेकिन अब नहीं छोड़ सकते हम. ये इम्पोर्टेंट है, लेकिन हम स्टडी भी कर सकते हैं, इसके साथ हिजाब भी हम वेयर कर सकते हैं, लेकिन हमारे लिए हिजाब इम्पोर्टेंट ही है. हम हिजाब को नहीं छोड़ सकते.
इस वर्डिक्ट और इस केस के पहले जब आप कॉलेज आ रहे थे उस वक्त हिजाब पहनते थे क्या अंदर?
हाँ, पहनते थे.
और अभी ये सुप्रीम कोर्ट, अभी ये सीजे के, चीफ जस्टिस के, इट्स गोइंग टू बी हर्ड बाय द चीफ जस्टिस, और अभी ये हिजाब बैन कंटिन्यू होने वाला है. इस मामले पे आपका एजुकेशन में कोई तकलीफ हो रहा है क्या?
हाँ, हो रहा है. कॉलेज हॉलीडेज आ रहे हैं, लेकिन हम ना अब एग्जाम्स आ रहे हैं ना, वो एग्जाम्स के लिए सिलेबस भी कंप्लीट नहीं हो रहे हैं, लेकिन हमारे लिए हिजाब होना ही है, स्टडी भी होना है, दो भी इम्पोर्टेंट है. हम रीजनल वो पहले से चला का है रीजनल लैंग्वेज, वो नहीं छोड़ सकते. हिजाब भी इम्पोर्टेंट है, उसके साथ स्टडी भी इम्पोर्टेंट है.
जस्टिस दुलिया ने जो अपील्स थे उसको अपहोल्ड करके यहाँ के गवर्नमेंट ऑर्डर को रिजेक्ट किया है. हेमंत गुप्ता सर ने उसको अपील को रिजेक्ट करते हुए कुछ हमने 11 क्वेश्चंस था, उसको सब अपील्स के हमने आंसर दिया है, इतना ही बताया, लेकिन और कॉन्स्टिट्यूशनल कुछ रेफरेंस इन्होंने नहीं दिया. इस वजह से हमें उम्मीद है कि यहाँ पर अभी चीफ जस्टिस ऑफ इंडिया के सामने हमारे जो बच्चे जो अपील डाले हैं वो क्या है, हमें आशा है कि डेफिनेटली वो हमारे फेवर में यहाँ के संविधान के फेवर में वो डिसीजन देंगे।
हम लोगों की पर्सनल उससे तो कोई मुद्दा नहीं है, तो गवर्नमेंट की तरफ से उठाया हुआ मुद्दा है। हमें तो इसमें कोई परेशानी नहीं है, क्योंकि हम प्रेशराइज है ही नहीं, हम हमारी मर्जी से पहनते हैं, तो हमें क्यों परेशानी होगी। इससे पहले तो कभी कोई नहीं था, क्योंकि हम लोगों को कोई परेशानी है ही नहीं। ये हमारे लिए हमारी प्रोटेक्शन है, क्योंकि हम
स्कूल में भी पहनते थे?
जी पहनते थे, हम स्टार्टिंग से पहनते हुए आ रहे हैं। ये सारी बातें तो अभी आई जा रही हैं, ये तो सिर्फ टारगेटिंग किया जा रहा है। और भी रिलीजन है जो अपना फॉलो करते हैं।
Ban of hijab will continue. As you know that Karnataka Education Act and rule does not permit any religious items inside the class. So we are very clear that no student can wear hijab inside the class.
ಎರಡು ಜನ ಜಡ್ಜ್ಗಳು ವಿಭಿನ್ನ ತೀರ್ಪನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾಗಾಗಿ ಇದು ಸಿಜೆಐ ಕೋರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನ ತೀರ್ಪನ್ನು ಎದುರು ನೋಡ್ತಾ ಇದೆ. ಸರ್, ಎಲ್ಲ ರೀತಿ ಬದಲಾವಣೆ ಮಾಡಿದ್ದೀವಿ. ಯಾವುದಾದ್ರು ಸೂಕ್ಷ್ಮ ಪ್ರದೇಶಗಳು ಅಂತ ಇರ್ತದೆ, ಅಲ್ಲಿ ಬಂದೋಬಸ್ತನ್ನು ಸರಿಯಾದ ರೀತಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದೀವಿ. ಎಲ್ಲ ರೀತಿಯಿಂದ ನಮ್ಮ ಪೊಲೀಸರು ಬಂದೋಬಸ್ತನ್ನು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಖಂಡಿತ ಶಾಂತಿ ಸುವ್ಯವಸ್ಥೆಯನ್ನು ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕಾಪಾಡುವಂಥ ಎಲ್ಲ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಂಡಿದ್ದಾರೆ.
Maulana ji, how do you look at this? The Supreme Court has forwarded this to the larger bench. There has been a contradiction in the decision of both the judges are concerned. How do you see that?
Whatever has been said in the Supreme Court by one of the honorable judge, we welcome that he has said that it is a matter of personal choice, and he has also said that it is related to the right to education. And education is very essential for all the children. So the manner in which this case has been taken up, and whatever one of the judge has said, we welcome that, and we also welcome that this case has been referred to a larger bench. And as far as the religious angle is concerned, since this matter is, we think that much more religious. And as far as Islam is concerned, we all must know that whatever Allah has said in the Quran and whatever Prophet Muhammad sallallahu alaihi wasallam, we consider all those things as the essential practice of our religion.
So here are the big takeaways from the Supreme Court's verdict that was delivered earlier this morning. Takeaway number 1, the hijab hearing will continue in the Supreme Court. Remember, it will be now referred to a larger bench. So that is, of course, takeaway number 1. Takeaway number 2, a 2-judge bench has now referred this case to a larger bench. It is an appropriate bench which will be formed by the Chief Justice of India. So that's takeaway number 2. Number 3, the judges gave a split verdict in the hijab case. So one judge gave a verdict for the hijab ban, one against the hijab ban. Takeaway number 4, Justice Gupta, Hemant Gupta, upholds the Karnataka High Court ban on hijab. So he, of course, said that that order from the Karnataka High Court was right. Now, takeaway number 5, Justice Sudhanshu Dhulia sets aside the Karnataka High Court ban on hijab. He is of the opinion that it is a matter of choice. It is what is enshrined in Article 19 of the Constitution. Takeaway number 6, Karnataka High Court hijab ban to remain in effect because of the split verdict and because the matter will now be taken up by a larger bench. Let's take you through some of the observations now and questions that were raised by Justice Hemant Gupta, who was for a hijab ban. Number 1, what is the ambit and scope of right to freedom of religion? He asked, one of the questions he raised in that verdict as he read out his own opinion of the entire subject. Number 2, in fact, is wearing of hijab an essential religious practice? This is the question which was asked by the Karnataka High Court as well, which has now been reiterated by Justice Hemant Gupta. Number 3, of course, is wearing hijab in school a right? He asked. He has raised 11 questions. This is number 3. Number 4, of course, as far as Justice Hemant Gupta is concerned, is there a constitutional provision for the wearing of hijab in educational institutions? He asked. Number 5, Justice Hemant Gupta, of course, asked, is the government order on hijab ban legitimate or not? He has, in fact, considered these questions before, of course, giving out his decision. These are some of the points and questions that he's raised before, of course, saying that he stands with the Karnataka High Court order to ban the hijab in educational institutions.